very appreciative of that, and we want to extend that to you as our thanks. There's only one issue before you that you have to decide, and that is whether or not my client, with premeditation and deliberation, took the life of his loved one, his fiancée, the one that he hoped to spend the rest of his life with on this occasion. The decision is whether or not, when my client left the police station after his normal course of duties that morning, when he put his service weapon into his belt, and when he went out to meet his woman, the woman he had hoped to go to California, the woman that he hoped to marry, when he packed, you know, his vehicle with all of the belongings, after giving notice that he was going to be discharged from his office as police officer, that he was going to leave and go to California, whether at that time he was premeditating a murder to occur in a cafe where, known to him, there would be countless witnesses. Now, there is been urged right from the offset in this case, one defense and one defense only, that this was by accident. There was no intent. There was no criminal design. There was no criminal negligence. This here was a mishap. This here was an act of God. What do you know about Mr. Diamond? He is an exemplary human being. He's a decorated war veteran. He is a highly disciplined individual. He is loved and respected by everyone in the community. His sergeant came forward and told you that with respect to his 2 years in the police force, that he was heralded, that he was commended for being superior police officer. You know that with respect to his relationship to this woman, that he loved this woman. There was no violence. There was never argument. There was never any suggestion of altercation. That his entire relationship to her was one of compassion and beauty and feeling, that he wanted to marry. He proposed marriage. It was she who refrained from the decision. It was she who didn't want the responsibility. Remember, 2 suicide attempts in the previous month. One where her life was almost taken. We have an unstable woman, a woman who couldn't care for her own child. A young woman who was beaten by her former husband, who was a drunkard. He had met with her in that diner every morning of their life together. She went out there to the vestibule to get the cigarettes. My client went out. He went out because he wanted to talk to her, nothing more. The gun was in his holster, just as he said, or in his belt. There it was. They had the conversation. There was only one word heard, no. No could refer to many things. No, I can't go to California. And it was at that particular time she grabbed the gun. She held the gun, as they had done so many times previously in their entertainment and in their preliminary kind of sport mannerism in order to prepare her. She pointed it at him. She was the one at that time that had crises in her mind. Remember, his car was loaded. He was going to California. He wasn't there to kill her. It's a crime without a motive. He had only manifested love. She took the gun. He tried to take it away from her. At that particular time, one shot rang out. The gun fumbled. He grabbed it again. His fingers grasped the gun, holding it tremulously. After all, a shot had just rung out. The one he loved there was bleeding. She was probably folding. And then the second shot came when he instinctually, through tremor, through non-cerebral activity, through motion, just grabbed the gun. It went off 2 times. Recall what happens then. He didn't run. He didn't lie. He knelt beside her, the woman he loved. He held her hand. He was shocked and he was frozen. He was dazed. It was all of the attributes of one who a great misfortune has befallen, and who one in the face of that misfortune is just in a state of shock. And as soon as that shock dissipated, and as soon as he could, at the earliest time when he overcame the grief that rendered him almost paralyzed, he told the story forthwith exactly the way it occurred. Remember, always in this case, and most significantly, when they have the burden, they have to produce evidence. They have to prove to you beyond a reasonable doubt that there was an intent to kill, that it occurred with deliberation, that he went out there and twice shot, and shot the second time to make sure that the deed was final. There's no evidence of that. There's absolutely no evidence. No one heard. No one saw. You will have to infer. You will have to deduce. But beyond that, you will have to speculate and conjecture. You cannot convict. This is a case that is consistent. This is a case that has all of the ring of veracity with regard to the death by misadventure, death by accident. There is no other logical inference. I submit to you there is only one logical conclusion in the case. This case is fraught with doubt. You must return a verdict of not guilty. Thank you very much.